We start off, we got two cases, correct?
Correct, Your Honor. Both.
And you are Caleb Landry?
Sir.
In 23 CR 908, the earlier case, you were charged with the state jail felony of burglary of a habitation on or about February 14th, 2023. And that carries with it no less than 180 days up to 2 years in the state jail. You'll understand if convicted.
I think you said burglary of a habitation.
I said burglary of a building, state jail, a burglary of a building,
Yeah.
not a habitation, a burglary of a building, which is lesser than a burglary of the habitation. It's no less than 180 days up to 2 years in the state jail. Burglary of habitation is a second degree felony. Do you understand what you're charged with here in this?
Yes.
And in 24 CR 2225, filed on October 23rd of last year, this states that on September 17th, 2024, that you committed the state jail felony of burglary of a building. Looks like the same building owner. The victim is the same as the previous case.
Probably discount tires.
And it goes on to state that you have, in this indictment, you've been convicted in 2005, felony offense of illegal possession of marijuana, a state jail felony out of Harris County, Texas. And in 2015, you were finally convicted in the criminal district court here of delivery of marijuana. And that doesn't affect the punishment range on this, does it?
Yes, Judge. If he's
Two prior state jail felonies on separate.
It has to a third.
Makes it a third degree.
Well, your punishment range is in two things that are problematic. Your punishment range will be enhanced if this is proven true to what would be a third degree felony punishment. It's state jail felony, but it's punished as though it was a third degree felony under law. And you were looking therefore at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Plus, if this is true, you are not eligible for probation in either of these cases. Do you understand?
Sure.
Okay, that's should be a lot on your mind here. What are we going to do today?
Your Honor, the state has tendered an offer of 12 months or 1 year in the state jail facility. And
how much time does he have credit, if any? Please. Okay, go ahead.
And Mr. Landry's advised that he's refusing that. Is that correct?
Okay.
That's
what you want to do?
The state's offer.
That's what you want to do?
Because
it's a hard decisions, but it's your life. Right now we're at a crossroads. It's either going to go that way or this way. Which one?
To be clear, one of the things that hasn't been stated, he is not eligible to receive probation from a jury.
I said that.
Should he do that, I will, if he continues down that path, I'll withdraw the state jail offer and give the enhancement notice on both cases, so that they're both dealing with third degree. Sure.
Okay, it wasn't. Yeah,
it wasn't included in the first indictment for some reason. We must have recovered them, but by the time he alleged to have committed the second offense.
But he has 17 days credit.
Okay, not a lot.
not a lot.
Let me ask something here. What's his bond?
What are your bonds? Each.
$5,000?
Each. Yeah. They were probably 5 each, Your Honor. That's what he seems to.
He's correct.
Okay. When was this bond posted? In 908? I'm looking at July 15th of 2024, correct? Is that right, everybody? That's what I'm seeing.
If that's right, then
It's $5,000
he's alleged to have committed the second offense while he was
in
on
September.
bond.
Yeah, we got a bond issue. You committed, according to the grand jury, and this second offense after you had been charged and in this earlier case, and you posted a bond of $5,000. Let's see, stand by. Looks like the amount of bond was fixed at $25,000 on July. I'm looking at another document that says July 20th.
He made the accusation may have run the initial arraignment may have been 20. I mean, I'm sure.
There's a 715, a $5,000 on seven that he paid on 715. But then there's a warrant for an arrest, a capias, burglary of a building, filed on July 16th. Okay. And the bond was fixed. I'm selling this.
He probably got
Says
it.
the amount of bond fixed by the court in this case is $25,000 here.
That was probably the initial arraignment. He didn't postpone.
Yeah, it was an arraignment.
And he got out on accusation after that in the warrant. Off the sometime after he was released on accusation in the bond.
But it's
On the
showing
warrant
5,000.
was set at 5.
Is that right? Lacey? It's showing 5,000 on this. Okay.
But he was arrested on.
And all of this was done though before it is alleged that he commits this next crime, 24 CR 2225.
He may have been out on the accusation on the second offense.
No, the second offense is on or about September 17th of 2024. All of this is July and July.
It's the initial bond he made in 908. Was made on 7/15 of 24,
Yes. Of,
$5,000.
yes. Then what?
And then it looks like. Looks like the bondsman surrendered that bond when he was rearrested. And he made another bond. In this case on 2/10 of 25.
Of how much?
The initial bond was.
No, I'm talking about the new bond.
Should have been 10 if there was an airport.
It wasn't an AFR, so it was a surrender.
Oh, all right.
Is it showing it's still 5,000? Yes.
Yes,
Okay.
still 5,000.
Okay. And then when did he post the bond in 24, 22, 25? The new thing.
10 of 25,
What was that bond?
5,000.
Yes. Well. On what day now?
2/10 of 25.
Okay.
That's after the.
Mhm. Yeah, that indictment had already been
Right.
prepared and has those prior convictions, and then you have that.
Right.
It just slipped. It must have slipped by somebody. See, on this indictment, here's what's, once again, I don't know how this is happening. On this indictment, on the face of the indictment, 7/20/23, that's me writing it. When I get the bond, I'm setting the bond at $25,000 plus a GPS device. Do you even have a GPS device? You don't even have that. I don't know what are my orders doing here that aren't being followed. I don't understand. But this was my orders on July 20th of 2023. Thereafter, those are changed. Or
Interrupt me as the court. I didn't have anything to do.
you didn't. Yeah, you're always the first suspect, but you've been cleared in this
I would
one.
like to take credit.
Anyway,
I don't have any notes to explain, Judge.
those were being changed without, and this court had authority over this case, and somebody else was changing these.
It was post indictment.
It was post indictment after I had signed these orders, which are equivalent to an order, which is inappropriate, but we'll figure it out. Anyway, this court doesn't find $5,000. I mean, I put $25,000 up here, but I did this before this indictment shows up.
Right.
And then this indictment shows up, another burglary of a building, which is alleged to have occurred on or about September 17th of 2024, after he was on bond here. Your bond's $100,000 in each case. Plus, you have to have a GPS device as a condition of bond. So this is irresponsible and of your part. And once you are charged with a crime and a bond is set, and you're presumed innocent unless found guilty. But these are probable cause decisions by the grand jury that you probably committed these crimes, which are what we base bonds on, as the probability a crime has been committed. And we use the circumstances of the case and the criminal history. Your first bond of $5,000 is the same type of offense that you post a bond. A few months later, you're committing another of the same offense, the same type of offense, as though none of this mattered to you. You weren't taking it seriously. You are now. We're going to take it seriously. You can't just keep committing crimes and think that you can just pay a small bond and not that additional information and additional crime commission won't have a bearing on it. It does. So those are the orders. You must have a GPS device, and the bonds are amended to $100,000 each because of your criminal history and the fact that you're committing the same crime after you posted a bond in the first case of a similar matter. Just a few months after that, you're committing the same kind of crime, according to the grand jury. Anyway, that's the orders of the court. Next event, you set these for trial. It'll be set for trial. Thank you. That's what we'll do. On Mr. Madison, that's you? Were you in court here? Why aren't you playing basketball for some NBA team and staying out of trouble?
His plan was to join the military.
Well, that's a good thing.
I used to do it.
That's a good thing. You're, as you know, you were charged on or about November 17th, 2024 in 2 cases, deadly conduct, discharging a firearm at or in the direction of other individuals. These carry with it in each case no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
All right. Right.
The state's conveyed an offer of deferred adjudicated probation.
What do you want to do with that? Let him think about it?
You want to do that?
Do you know what deferred means? That you won't be found guilty.
Yes, sir.
So long as you follow the terms and conditions of probation, you do well. It's shortened to 1/3 of whatever the term is if you do well. But it's your choice. This is your life. And nobody can force you into anything. It's free will.
Yes, sir.
You just have to be wise in your decision making.
Yes, sir. I understand that.
What do you want to do?
I was from taking the trial because
Okay, then that's what we're gonna do. It's set for trial. Okay. And next is Willie Thomas. Oh, by the way, I don't know if you know these people who were victimized. It were the victims in here. I don't know if you know. You can't have any contact with these people.
I don't even know.
Okay, good.
I don't know.
And nor anyone on your behalf. If we found that out, that they were being called or on your behalf, or you tried to touch base with them, we look at that as trying to change, tampering with a witness. Your bond would be revoked and you'd sit it out in jail. You don't want that.
Yes, sir.
Okay.
I don't know.
And talk to him about what all this means. So you can think, we're hitting you with this and you're only having 30 seconds to think about it, and that's not fair. You want to think about it. This is one direction or another in your life. And he's a good man. He's a smart man, and he'll guide you along, and he'll tell you what he thinks. He does this all the time. He knows he's got a feel for what's in the best interests of his clients. Okay.
Thank you.
Yes, sir.
It's not on the house.
Colton Barrera.
No, this is Willie Thomas.
I'm sorry. Yeah, Colton Barrera is Mr. Parker's case. and Willie Thomas.
We'll defer to the state on this.
Okay,
He has a new case that's being indicted next week, Your Honor, so
Alright.
we'd like to reset it.
okay. You're charged right now with the state jail felony of theft of a firearm. Do you understand? That carries with it up to 2 years in prison, and a fine up to $10,000. What is the new case that you're looking at?
It's an aggravated robbery, Your Honor.
That's not good. That would be a first-degree felony.
Yes.
Well,
I never heard of that case.
that's not the point. It's going to go in front of the grand jury and it's been, all cases are investigated first. You don't have to be notified about anything, you know. They can take this to the grand jury without alerting you because they feel like they have evidence to submit in front of a grand jury, and they can do that. But if you are indicted, I can guarantee you what it's going to affect is the bond in this case. If is it a crime committed after this indictment,
Yes.
which is March 19th?
Yes, Your Honor.
Yeah. If it's indicted, you'll be back up here and we'll deal with a new bond setting, depending upon, well, that is a most serious crime. And the bonds will be probably very high. So with your attorney, Mr. Parker, and the state's attorney, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges, sir, that on or about November 21st, 2023 in Jefferson County, Texas, you committed a third-degree felony of assault, family violence with, by impeding, choking somewhat. Do you understand what you're charged with here?
Yes, sir.
This is a third-degree felony if convicted, and so you are facing no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Agreement's been reached. You will be pleading guilty, placed on deferred or unadjudicated probation. What is this? Is this a number?
6.
Looks like a G.
I know, I've tried, it was
Oh.
delayed every time we tried to write it there.
All right.
You know,
The tablets for the attorneys, Judge, they have
They're
this
goofy.
massive delay.
Yeah, and then you're writing, and then I've seen, we're writing, you're putting the stylus down, and it's appearing like a half an inch to the left or the right.
Yeah, I picked it up and I'll say on the signatures.
Okay, is that your understanding of the agreement?
Yes,
It would
sir.
be a non-binding recommendation. I can actually assess probation. It's in the court's discretion up to 10 years in prison, but I listen to what the lawyers want to say and consider that.
Yes, sir.
But deferred or unadjudicated probation means you won't be found guilty so long as you follow these terms and conditions of probation, which I tell people go, oh my God. I mean, they're the same kind of things. Don't commit a crime. That's what I have to do.
Yes, sir.
Live honestly. Don't harm people. Give each person respect. I mean, that's what they deal with. And everybody really is kind of on a probation of life for just treating others with respect. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Sure.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 made a part of the record for all purposes. Pre-sentence report is waived to you.
You wait a Judge.
Nothing further. I'm going to follow this agreement. What about the length of term of probation?
Your Honor, I would just represent to the court. I
Any
think
objection to he's asking for 6? Any?
No, sir, I think it's fair.
Okay. I'm going to find you were pleading guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer any finding of guilt so long as you follow these terms and conditions of probation. We're going to go over these here with the probation, you and the probation officer. This will be a term of 6 years. Make sure you follow these. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 10 years in prison. So Do well. Also, you do well, it gets shortened in 1/3. You know what a third is of 6? 2. It's,
It's gonna be fine.
there is no
No.
time.
No, fine, okay.
There's no restitution here. You think?
No, Judge.
Yes. Thank you, Judge.
You're please see the probation office.
Thanks, Judge.
Yeah, okay. How's the family?
They're good.
Uh,
Andrew's, she's a federal employee, so her job is always,
Peace officer, which carries with it up to 20 years in prison if convicted. And Mr. Cole is your attorney. He's a fine man and good lawyer. I'd listen to his advice if it were me, but everybody has their free will. He's a good leader. He'll guide you through the minefield. And what do we want to do today?
If we could reset it a week, Your Honor.
Is a week good for you? Okay, well, we sent 1 week. I appreciate it. Here, get a resetting. Thank you. Yes. Perry Ashworth. Mr. Ashworth is present. With his attorney, Mr. Kimler, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
You know, Shari, just to be clear, for the board, Mr. Ashworth has a prosthetic leg that his leg was amputated in an occupational accident years back, so that's why he's legally.
That's okay. Okay. He actually is standing more upright than a lot of the folks who are healthy stand. I hate to say, but he's doing, I appreciate him. Okay. In summary, sir, this indictment alleges in paragraph 1 that on or about January 10th, 2023 in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. Now, that would be otherwise a misdemeanor, except this indictment goes to allege you have 2 or more prior convictions, which then make it a felony. And it states in November of 2020, you were convicted twice out of County Court at Law number 2 of Jefferson County for DWIs, operating motor vehicles while intoxicated. So paragraphs 1 and 2 then therefore together constitute a 3rd-degree felony. And that means that you are facing no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand all of that?
Interesting.
Yes. An agreement's been reached where you would be pleading guilty to paragraphs 1 and 2, this 3rd-degree felony. Found guilty, sentenced to imprisonment for 5 years. That would be suspended. You would be placed on regular probation for 10 years. There would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty to this indictment voluntarily and because it is true as it is alleged?
Yes, sir.
And these 2 prior convictions in 2020 of DWIs in paragraph 2 in this indictment, are those allegations true and correct as they are alleged? And are you pleading true and correct to that voluntarily?
Sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. Then that's a guilty plea, paragraph 1, true to paragraph 2, constituting its 3rd-degree felony, operating a motor vehicle while intoxicated on a public place. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Is a pre-sentence report waived?
So, Your Honor, I think as far as I would anticipate on the 10 days jail time, Mr. Ashworth would request that you're allowed to do that on the weekends, not go into custody today.
Okay.
I don't have a problem with that.
If anything,
And the reason for that is.
That's okay.
Again, the prosthesis.
that's okay. Actually-
It's problematic with extended
Yeah.
stays. So.
It's kind of, you can do that. And I always allow people, if they want to do it on weekends, but I'll tell you what is said to me is when they go in and they go on weekends, by that second weekend, often I hear them say, can you just convert it to straight time? Because It's, you've got that gap. You can do whatever you want, but I'll defer to people. If they want to, if they can, a lot of people need to work during the weekday, for instance, and I work with them, but they'll say, you get out on Sunday, you have to go in by 6 o'clock Friday. They release you at 6 p.m. Sunday, and then you're looking forward to next Friday.
Yeah.
Until it's over with. And
Yes, sir.
some people have that. That's hard to bear. But we'll work this out for you. I'm going to find you were pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this third-degree felony. I now find you guilty beyond a reasonable doubt here. I'm following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 5 years. That is suspended. You are placed on regular probation for 10 years, and there will be terms and conditions of probation here that are being prepared by the probation office, which are normal and customary for this. Make sure you follow it. If you fail, your probation can be revoked and you can be sentenced no less than 2, no more than 5 years in prison. Also, when do you start your jail time? This Friday?
Next Friday.
Your Friday week? Okay,
Yeah,
that's good.
that'd be-
Friday
give
week
me time
on the 27th. Yes, sir. On or before 6 o'clock p.m.
Okay, so,
And you'll do it 5 consecutive
Yes, sir.
weekends.
and if you don't, then that can be the reason that your probation is not.
Okay. Sometimes, no, it takes away.
Yeah.
Was there any fine on this?
No.
No fine.
No.
Probation.
But the initial time, from the law is transferred.
Thank you so much.
Okay, just talk to him. Thank you.
Thank you.
Thank you, Judge.
How are you? Come on up, Mr. Ardoin.